morality in two places. Apart from here, you will also see morality in Article 25 and 26, which closely follow as our discussion right after this. Now, let's quickly go through Article 19. There really is not much to do as far as Article 19 is concerned. Article 19 is speech and expression. Speech means verbal, expression means anything in any form. Of course, it will have a close association to dissent, it will have a close association to censorship, it will have a close association to several identity-driven rights. The jurisprudence around speech and expression is that it has largely been used as a right which is an instrument of democracy, and of course has had some correlations with rights pertaining to privacy, identity, orientation, autonomy, and bodily integrity. The reasonable restrictions to freedom in speech and expression, as you can see, are the longest than any other right. It has sovereignty and integrity, security, friendly relations with foreign countries, public order, decency or morality, contempt of court, defamation, and incitement of an offense. Now, do you need to memorize these? I don't think so. Out of these, sovereignty and integrity were added later, and this was largely done in, I think, 1963 as a response to the Kedarnath judgment, which had softened the sedition law, saying that you would require a direct impact on violence for it to be considered an issue of sovereignty and integrity. You will see sovereignty and integrity therefore added as a reasonable restriction in two other rights, because speech and expression, peaceful assembly and association also have a correlation to protest, to strike, and so on and so forth. The second right is the right to peaceful assembly without arms. The reasonable restriction to the right to peaceful assembly without arms is the following: 1. Sovereignty and integrity, and 2. Public order. The third fundamental right is the right of association, unions, and cooperatives. It has 3 reasonable restrictions: morality, as I was telling you, sovereignty, integrity, and public order. Of course, there's a series of Supreme Court judgments as far as Article 19 is concerned. Movement and residence and settlement, 19(1)(d) and 19(1)(e) will have the same fundamental restrictions. General public interest, and very, very importantly, protection of scheduled tribes. It does not mention scheduled castes. In derivations and applications, you could still look at it, and therefore what we're effectively looking at, what we're effectively looking at is this protection of scheduled tribes. So for example, things like the 5th schedule, 6th schedule, autonomous councils, inner line permit areas, these are all applications of protections of scheduled tribes. And of course, profession, occupation, trade, and business. A, general public interest. 2, the government can lay down any qualifications for you to do any job. And 3, if the government wants, it can reserve any sector it wants to for its presence and its presence only, therefore giving effect to something called nationalization. And that's effectively what is called Article 19. What you need to know with Article 19 is that if Article 19 includes the freedom of speech and expression, it means you have the right to have a speech and expression about the government. For you to have an opinion about the government, you need to have information about the government. And for that, you need information from the government about the government to have an opinion on the government. So therefore, you have what is called right to information as an implied fundamental right under Article 19. And if you remember yesterday's Supreme Court judgment on electoral bonds becoming unconstitutional, and this is how recent I record your lectures so that you get the most updated in your lectures, it is important for you to know that right to education was a conflict area with respect to right to information was a conflict area with respect to electoral bonds. Because very simply, if I do not know who has given how much money to a political party, then as a voter, for me to take an informed decision on who to choose in the next election could therefore be compromised, and therefore my right to information becomes a considerably difficult problem. So that was something that was discussed. It also had an implication to right to privacy, that if I have decided to vote for a political party, or if I've decided to donate to a political party, who I am and what I have decided to donate to is a matter of my privacy. And if it is a an instrument of my privacy, then therefore it should be held within myself as to who I can donate to, and I'd like to keep it confidential. So RTI and privacy were issues that were discussed in the electoral bonds judgment. But as far as the prelims is concerned, to my best understanding and to the best of my wisdom, I genuinely think Article 19 is the lesser done, the better. Now comes Article 21. Much like Article 19, Article 21, because of the nature of it being so open-ended, becomes extremely unlikely. But let's go through it because it has some key concepts that we've discussed in jurisprudence, rule of law, etc. in the earlier lectures. Now, Article 21A is available against the state. It's available only for citizens and foreigners. It's available for all citizens and foreigners. And very interestingly, it contains the words procedure established by law, which simply means if there is a procedure and the procedure has been implemented, then it is good. The government can restrict your life and personal liberty through any procedure that the government has because the law has passed that procedure. Is it good procedure, bad procedure? By a simple meaning of it, doesn't matter. Which is exactly why the Menka Gandhi case in 1978 happened. We've discussed this earlier. So in that case, it was understood that the procedure established by law should also include procedural due process, which means, okay, the procedure has been passed by the law, and just because it has been passed through a law doesn't necessarily make it a good procedure. So I'd like to check the fairness of the procedure, and that's effectively what the Menka Gandhi case was about, because if the Passports Act allowed you to take someone's passport away and you were not giving somebody the right to even question that decision, the procedure seemed to largely be unfair. And because of this, it means that the procedure, if the procedure is unfair, this means effectively that there is something wrong with the procedure. So if I have to check whether the procedure is unfair or not, I would have to apply what is called principles of natural justice. Now, principles of natural justice mean two things. One, we've discussed this before, there should not be any bias in any form. And two, there should be an opportunity given to everybody to be able to access a fair hearing. So for example, if the judge has a conflict, or for example that let's say you have a financial stake in an administrative inquiry, or you have a relative who's going to get a tender and you're sitting on the tender committee, it is violating the first principle of rule against bias. The Latin phrase of it is called nemo juda causa in sua. The Latin phrase is not asked in the exam. You should know what rule against bias is, and the rule for a fair hearing, which effectively means, for example, if there's an inquiry against you and you don't even get to read the charges against you, you don't get to cross-question, cross-examine, you don't get to even rebut the witness or the evidence, then it's not really a fair hearing. So therefore, the second principle, the odi alteram partem principle, is the principle of natural justice. So, procedure established by law to procedural due process of law to something called principles of natural justice. This is effectively the outcome of Article 21. Because of the Menka Gandhi case, there are two things that happen. What if, and this is important, what if Article 21 tells you life and personal liberty? Article 19 says you have speech and expression, you have peaceful assembly, you have the freedom of association, movement, residence, settlement, profession, occupation, trade, and business. Now, there are obviously a lot of things in common. If I do not allow you to speak, I will also take your personal liberty away. If I arrest you, I am of course taking your movement away and your life and personal liberty by taking the dignity out of it. So therefore, in that scenario, in that specific case, what happens? There is a clear-cut relationship between 19 and 21. And ultimately, why somebody is doing it is generally through a law, which means the law has created some bias because the classification is a problem. So Article 14 also gets attached to 14, 19 and 21, and therefore you have the holy trinity of 14, 19 and 21, and that's exactly what happens as an outcome in the Menka Gandhi case. So what happens is, If there are freedoms that come both under 19 and 21, you will see if the violation is justified under the reasonable test of 19. You will see if it fulfills the requirements of Article 21, and you will also see if it is fulfilling the arbitrariness test of Article 14. Freedoms which are only about 21, you will see 21 plus 14, but if it's 19 and 21, you will definitely see 14. This is the outcome of the Menka Gandhi case. It's important for this year's prelims exam because last year they asked you principles of natural justice and due process of law. Now, Article 21 means a ton of things through ton of judgments: the right to livelihood, shelter, food, health and medical care, life with dignity, death with dignity. Post the Supreme Court judgment which has not allowed for civil union of homosexual couples, you do have the right to marry, but only for heterosexuals. This has been a PYQ before where the question was, do you have the right to marry? The answer was yes under Article 21. Now do you have the right to marry? Yes, only if you are a heterosexual. Right to privacy has also been a PYQ. Right to privacy is largely a right under Article 21. Because of privacy also correlated to surveillance, it will also have an intersection with 19, and therefore 19 becomes a subsidiary right to privacy, but the primary right that privacy comes under is under Article 21. You also have something called the right to legal aid, and I will discuss this in the context of criminal justice. You have the right to fair and speedy trial and the right to clean and a healthy environment. Legal aid has also been a PYQ favorite. There have been 2 questions in the last 10 years, and the right to a clean and a healthy environment includes that the court has come up with several principles with respect to environment. For example, polluter pays. For example, sustainable development. For example, public trust. For example, intergenerational equity. These are all Supreme Court derivations on what the right to environment actually substantially should and could mean. Now, this to my mind again is more than enough as far as Article 21 is concerned. Now that we've done 14, 19 and 21, and because they were related, we should now look at criminal justice rights, which I will teach you the basics of, and then I'll get you through some criminal procedures because that has been relevant as far as the UPSC is concerned. Now, let's start. When we're looking at Articles 20 and Articles 21, you've got to understand the following things. First, Article 20 gives you general principles with respect to criminal justice. It tells you the following things. 1, it's available only against the state. 2, it's for everybody, citizens and foreigners. 3, it speaks of 3 specific criminal principles. 1, a criminal law cannot be applied on a backdate. For you to be charged with a criminal offense, it has to be a criminal offense on that day. So if today you're committing a crime, it should be a crime under some law, and the punishment of today is the punishment that you're going to get. Tomorrow the government can't go back in time and increase your punishment or increase the severity of your crime. 2, 1 crime, 1 punishment. 2 crimes, multiple punishments. You cannot be charged or prosecuted. The 2 words are, you cannot be prosecuted or punished for the same crime more than once. Different crime? Yes. Civil and criminal? Both. The same crime can attract many sections of different criminal laws? Yes. And whatever the maximum punishment that the judge deems fit could be given to you, shall be given to you. And you cannot be compelled to be a witness against yourself. This is also a principle of natural justice. It's also a very important principle of criminal law. You can't be forced to give evidence against yourself. This is also why any testimony given for the police has to be verified in a court of law. This is also why things like narco analysis have been declared unconstitutional by the Supreme Court. Now, Article 22 is where the kicker lies. Article 22, very specifically, Article 22 refers to arrest and preventive detention. So let's understand what this is. A simple tabular comparison is more than enough. Anything beyond this is not relevant. Arrest is generally post-offense. Preventive detention is pre-offense. By the nature of the word, this is what it means. Now, legally, there is a difference between arrest, remand, etc., but that's not for you for the prelims exam. Whether you've been arrested or you have been preventively detained, you have the right to be informed that yes, this is why you've been arrested or preventively detained. Absolutely. You have the right to inform other people that you've been arrested or preventively detained. Here's the difference. If you've been arrested, yes, but the Constitution is silent on whether you have the right to inform other people that you have been preventively detained. The Supreme Court, in the case of D.K. Basu, says that you should, and there are massively brilliant guidelines given by the Supreme Court. Now, protections against arrest is available for everyone, citizens and foreigners, but protections against preventive detention is available against citizens, it's available against foreigners, except those foreigners who are enemy aliens. Why? Because enemy aliens could be spies, could be agents, etc., etc. Now, another crucial difference. If you've been arrested, you have the right to legal representation. But if you've been preventively detained, you don't. Can you challenge your preventive detention order? Yes. But you have the right necessarily to a lawyer? No. If you've been arrested, you have the right to be presented before a magistrate within 24 hours. Now, you don't have that right if you have been preventively detained. This is simple enough to know for Articles 20 and 22, but it also gives me a pathway into criminal justice. See, what has happened is in the last few years, the UPSC has asked fairly enough questions as far as criminal justice is concerned. They've asked you who regulates prisons, what is the difference between a judicial custody and a police custody. To be very honest, any question on criminal justice could be answered in two ways. One, separation of powers, LENJ, which is rule number 3. And two, the fact that law and order is in the state list. So let's apply this. Police custody means you're in the custody of the police. Judicial custody means you're in the custody of the judiciary, which simply means that the police cannot interrogate you without the permission of the judiciary. This is essentially separation of powers. Now, similarly, prisons are regulated by state governments. If prisons are regulated by state governments is a plausible statement because law and order is the state. So administration of law and order would effectively be the state because the police manages the prisons. Police is the state list. So therefore, prisons are the state list. So by just this, you can answer the criminal justice questions very honestly. But I will still get into some basics of it so that it's easy for you to understand. First things first, when we're getting into criminal justice, there are a few basic things that we've got to know. The basic stages of criminal justice is, first, the crime has been committed. Then the crime has been investigated. Then the crime has been tried. And then, of course, the outcome of the crime. In criminal justice, these are your 4 basic trials, or these are your 4 basic stages. Now, there are effectively 6 constitutional guarantees as far as criminal justice is concerned. Guarantee number 1, if there's something that is unfairly done to you, it is a violation of Article 14. For example, if a criminal law is unfairly applicable to you, it is a violation of Article 14. 2, if principles of criminal justice are not being applied to you, if you've been subjected to diverse criminal laws, it's a violation of Article 20. 3, if you have been illegally arrested, you're fundamentally being violated of Article 21. If you have not been given adequate protections of arrest or preventive detention, your Article 22 also seems to have been violated. And 3, you also have the right to justice and legal aid under Article 39A, which is the directive principles of state policy. And you have the right to go to a court. You have the right to question a bad criminal law under Articles 32 and 226. So there are effectively 6 constitutional guarantees that exist for us. Now, once we understand this, we must also then understand the basic stakeholders as far as the criminal justice system is concerned. Your basic stakeholders are, first, you of course have the police. Fairly simple, police is under the state list. 2, this is the interesting part. You have prosecutors. Now, prosecutors are effectively appointed by the state government because they are the ones who are going to try the case against the defense. 3. Magistrates. There are two kinds of magistrates, judicial magistrates and executive magistrates. We've done this largely because we wanted to implement a directive principle that says separation of powers from the legislature and from the executive and the judiciary. So the judicial magistrates are appointed by the High Court of the state. The executive magistrates are appointed by the state government of the state. The difference is in the powers that they have, in the punishments that they can give, and so on and so forth. Magistrates are low to low criminal courts, and then of course you have the courts in our country, which are a very important stakeholder. Apart from this, you would have defense counsels if there are prosecutors, and you would also have witnesses just in case to cross section and to substantiate your evidence. And you would have prisons which are regulated by the state government. So this is generally what your stakeholder is. Now comes the larger question: who can punish for what? Now this is technical, so just bear in mind and just bear with me for some time. Basically, the Supreme Court can give you any sentence. Everybody has criminal powers. Supreme Court has criminal appellate powers. The Supreme Court can give you any sentence which is authorized by law. The High Court also can give you any sentence which is authorized by law. Then you have things called the Sessions Court. Now, the Sessions Court would have a little bit of a limitation, which means that the Sessions Court can also give you any sentence authorized by law, but a sentence of death. And if the Sessions Court is giving you a death sentence, it has to be confirmed by the High Court. Then you have additional sessions judge. They can give you punishments for about 10 years. 10 years, up to 10 years, and or fine. Then you have judicial magistrates who can give you punishments till about 7 years. Then you have the chief metropolitan magistrate who can also give you for about 7 years. And then you have metropolitan magistrates who can give you for about 3 years. And then you have judicial magistrate first class who can also give you for 3 years. And then you have something called a judicial magistrate of second class who can give you a punishment for about 1 year. Obviously, the fines would also reduce over a period of time. But this is largely how it works. In this entire process, when you are in trial, you are entitled to bail. What you must know under all circumstances, and this is the important part, both the magistrates and the police can give you bail. There are some cases where you have a right to bail. There are some cases where you don't have the right to bail. Now, amongst all of this, what is actually important for the exam is the fact that you have legal aid. Now, legal aid becomes extremely important. It's also a fundamental right we were discussing before. The Legal Services Authorities Act of 1987, if I remember correctly, Section 12 gives you a list of people who are entitled to legal aid. So under Section 12 of the Legal Services Authorities Act of 1987, the following people are entitled to legal aid. And it is closely related to vulnerable sections and social justice, but legal aid has been a UpSC PYQ favorite. There have been at least 2 questions in the last 10 years, and therefore they become important from that context. So the first thing is member of a scheduled caste or a scheduled tribe. 2, if a person has been a victim of human trafficking or begar. Second. Third, if the person is a woman or a child. Fourth, if a person has any form of disability recognized under law. Fifth, if there is any person under circumstances of deserved or undeserved want who has basically been a victim of a disaster, a person who has been a victim of violence, a person who has been a victim of caste atrocity, a person who's been a victim of a flood, a person who's been victim of an earthquake, of an industrial disaster, or a drought for that matter. These are people who are entitled to legal aid. Very interestingly, even an industrial workman is entitled to legal aid. followed by the industrial workman. You also have a person who's in custody, which is why you would often hear, if you can't get a lawyer, we'll get a lawyer for you, when the police is trying to get you in custody. And lastly, there is also an economic criteria. This was where the UpSC question was. A person who makes a person who's in the receipt of an annual income which is less than 9,000 rupees or higher as may be prescribed by the state government. And if the case is before any other court than the Supreme Court, then the person should be making less than 12,000 bucks as may be prescribed by the central government. So if you're before the state government, less than 9,000 bucks. If you're before the Supreme Court, then 12,000 bucks. There's an economic criteria. So this is enough for us to understand who are entitled to effectively what is called legal aid. Now this takes care of articles 20 and 22. We are done with 18. We were done with 19 and 21. Let's quickly now move to the rest and finish it up. Exploitation. Exploitation articles are closely related to articles 23 and 24. Exploitation articles under 23 and 24 largely deal with two parts. Article 23 deals with exploitation. 24 deals with a narrower form of exploitation, which is called child labor. Now, Article 23 is available for both citizens and foreigners. Like untouchability, it's also not a self-executory act. And like untouchability, we've passed two laws, the Immoral Trafficking Prevention Act and the Bonded Labor Act. Now, both of these become extremely important because they are the ones that actually criminalize what is called forms of human trafficking. Now, Article 23 also allows the state to impose what is called conscription, which is basically compulsory service of the people. Now, there are essentially on the following grounds that the state cannot discriminate while making it compulsory for people to do something. Israel has this in the form of military conscription. So caste, class, religion and race. Very interestingly, women have been excluded from this because the most common form of conscription is a military conscription, and the orthodox thinking is that women don't have the physical ability to serve in the armed forces, which thankfully now is changing in due course of time. Now, to understand the basic difference, again, simple. Three variables: the consent of the worker, the legality of the work, and wages paid. With human trafficking, there is no consent, the work is illegal, and the wages could be paid. A very common form of human trafficking is prostitution, and the Immoral Trafficking Act is the regulating law on prostitution, and it basically says commercial prostitution is not permitted. What it also effectively says is that any form of, you could say, public prostitution is not okay. Running a brothel is not okay. Being a pimp is not okay. Calling for people in public places is not okay. But if somebody is doing this in their private room, in their private residence, it's perfectly okay. Forced labor is where there is no consent. The work could be legal and you may or may not be paid. In fact, the Supreme Court has said, even if you've been paid for something you did not want to do, it is still forced labor. Third, Begar is where you wanted to do this, you agreed to do the work was dominantly legal, but you were not paid for it. So it's basically unpaid labor. This is exactly what is Article 23. Now, Article 24 is available for both citizens and foreigners. It is non-self-executory in nature, which means like 23, you will also have to make a law for prohibition of child labor. What it basically says is, children below 14 cannot work in dangerous places. Agreed. But there are so many ifs and buts that are left open-ended. So what happens is you have the Child Labor Prevention Act, and it gives you two major clarifications. The first clarification is, if you're below 14, you can actually work in a family-run enterprise or an audiovisual entertainment industry. Children below 14 cannot work in dangerous places means that children below 14 can work in non-dangerous places. So they've identified the non-dangerous places. It's as simple as that. Now, 14 to 18, they've created a new class of people, a new class of adolescents. They can work only and only, they can work anywhere except for three places. They cannot work in places which has inflammable substances. They can't work in places which have mines, and they can't work in places which have explosives. Now, Interestingly, you're allowing a child to work, but under Article 21, you're making it compulsory for a child to go to school. So therefore, you have to read 21 with Article 24. 21 is, it's available for the state. It's for citizens and foreigners both. It's free if you can't pay for it. It's compulsory means if you're willing and you're able to go, which basically means your parents have given you consent. Then you're entitled to go to school between 6 to 14 years. Now 6 to 14 sort of overlaps with this. So a child is willing to go to school, is able to go to school, has the parental consent to go to school, and therefore if the child is not going to school, that means it's the state's fault. On the other hand, you're allowing the child to also work in a non-dangerous place. So therefore, Article 21A has to override Article 24, and therefore it is that ठीक है, if you want to go to work, you can go to work, but the work will have several limited conditions as mentioned, as if it was a family-run enterprise or it was an audiovisual industry. So that's the basic understanding of Articles 23 and Articles 24. Now, 25 to 30 has to be done together. They deal with religion and minority rights. There has never been a question from here in the exam, but given the fact that the Aligarh Muslim University case has been in the news, so minority rights could be a question. But again, the question on minority rights will only and only come if it comes from core constitutional provisions. There are, of course, tons of Supreme Court judgments on this, and they're very important for the mains, but particularly not important for the prelims. You've got 25, 26, 27, and 28. They deal with freedom of religion, and you've got 29 and 30, which deals with minorities. If you do them together, because religious minorities are associated to religion. Let's quickly look at what they are. First, Article 25 is available for everyone. So basically, Articles 25 to 26 are available to everybody, to citizens and foreigners. Let's do this block first. Article 25 tells you have the right to conscience, practice, profess, and propagate. Conscience means you have the right to believe in a supreme being or not, and how you believe in the supreme being is entirely your call. Practice is however you want to practice the ceremonies and the rituals associated to your religion. Profess is if you want to disclose the religion that you have. That's generally through wearing religious symbols, etc. That's how you would generally be professing religion. And when you say you've got to propagate religion, you're essentially saying you have the right to encourage people to join your religion, but by law, if I remember correctly, the Stanislaus case, you do not have the right to convert anybody to your religion. Now, Article 26 gives you 4 rights under 26A, B, C, D. Effectively, it means you have the right to establish and maintain religious institutions. You have the right to manage your own religious affairs. You have the right to movable and immovable property. And you have the right to administer property according to such law. So very interestingly, religion has the right to property. So religious institutions have a fundamental right to property, but everybody else in the country does not. That's the implication and the understanding of Article 26. If you actually read 25 and 26 together, the Supreme Court will intervene on what is an essential practice, what does propagate mean, how much can you establish and maintain, how much can the state regulate your institutions, what is the kind of acquisition that you can have. All of this will lead to what is called essential religious practices, which gets applied to cases like Sabrimala and now the recently in news Uniform Civil Code. Article 27 is extremely irrelevant for the prelims exam. It simply says that there's absolutely no tax that you have to pay if you are doing something which is a religiously promotional activity. In fact, the government for a long time had something called Hajj subsidy, and by a petition made by a member of the Islamic community, the government also withdrew the Hajj subsidy, because the principle was that if you have to go for Hajj, you've got to go for Hajj with your own money and not somebody's charity. Article 28 simply says there should be no religious instruction in fully funded state institutions. So this means that when we studied the Ramayana Mahabharata in our schools, that was essentially taught as moral philosophy, as literary philosophy, not as anything else. Articles 29 and 30, very, very interestingly, largely are two very different articles. Article 29 is for all citizens, but Article 30 is for citizens who are minorities. We've got the Minorities Commissions Act. We've got several laws which identify minorities. The latest minority to be added was, in fact, the Jain community. Now, what does Article 29 say? It effectively says two things. Minorities have the right to conserve their language, script, or culture. The best way to conserve language, script, or culture is to ensure it passes on from generation to generation. So education becomes a very strong way to conserve. And the second part of Article 29 says there shall be no denial in state-funded institutions on the basis of caste, religion, race, or language. It simply means that if the institution is funded by the state, then there should not be any discrimination on the basis of caste, religion, race, and language. Now, Article 30 speaks about if you are a religious or a linguistic minority, you can set up an educational institution if you feel like, and you have absolute freedom to do so. How can the state intervene will depend on state funding. We've got two remarkable judgments, TMFI, PA and Amdar, which get further accentuated by the Islamic Academy case, which is also why in correlation you have Articles 15.5 added to that corner, and there's a lovely triangle that gets built up because of Article 30 and Article 15 clause, Article 30, Article 19, 1 clause G, and of course Article 15. So anyway, that's not for the prelims exam. If you're an educational institution, education is a welfare commodity, so the state has the right to fund educational institutions. If the state funds educational institutions, the state cannot discriminate against your institution just because it's a minority institution. And depending on state funding, will there be state intervention, which is essentially the Aligarh Muslim University case. What you need to know are Articles 29 and 30 and nothing else apart from Articles 29 and 30. Now, quickly moving to the second last part, which is your writs. Now, we've seen two questions in writs very, very recently in the last 10 years. Let's get this absolutely right. There's a little bit of concept here. Let's get our basics of writs right. So, writs is a court order to uphold a right. Both the Supreme Court and the High Court can issue exactly the same kind of writs. There's absolutely no problem whatsoever. The Supreme Court and the High Court will issue the exact same writs. For what purposes do you issue these writs is a different question altogether. Now, if it is a fundamental right violation, then you can go to the Supreme Court or the High Court directly. But as we've discussed at the beginning of the lecture, if it's a constitutional right or a legal right violation, then in that case, you can directly only and only go to the High Court. So this means High Courts can directly issue writs for fundamental rights, constitutional rights, and legal rights. So this means the High Courts would effectively have wider powers because they can issue writs as the court of the first instance in a larger number of rights cases than the Supreme Court. What you must know is, going back to the core concept, judicial functions of higher judiciary is not state. And judgments of the higher judiciary therefore cannot be law under Article 13.2. For the same reason, writs cannot be issued against higher judiciary. Because if you're issuing a writ from a Supreme Court to a High Court, from a higher bench Supreme Court to lower bench Supreme Court, from High Court to Supreme Court, you're effectively telling them that they have violated a fundamental right. If they were to do that, then they would never be able to judge whether the right was actually violated or not. Very interestingly, without prejudice to the Supreme Court, this is categorically mentioned, the Parliament can confer the Supreme Court writ powers to any other authority or the court that the Parliament may effectively deem fit. And the Supreme Court Rules Order 38 has a list of things that you've got to do for petitions under 32. It also contains rules for public interest litigations. Now, when X is coming to a court, there has to be a locus standi, which means who are you to the case. And if the court is hearing your matter, the court should have jurisdiction. Fairly simple concepts. Now, there are 5 writs. Let's do them as far as the exam is concerned. You've got the writ of habeas corpus. The primary function of habeas corpus is what is called illegal detention. Now, if you have been illegally illegally detained, you yourself can't come to court. And if illegal detention has happened, then the state has